They have clarified in Ignacio Juarez that it is actually a pattern of conduct that prevents supervision, that precludes supervision. And I think that is fully consistent with what the Fifth Circuit said in Swick and the Fourth Circuit said in Thompson.
That's one court's view. I think the point that Justice Gorsuch is making is that we would have to decide, as a matter of common law, which of those approaches is right.
Well, Justice Sotomayor, the only point that I'm making is that I believe there is actually a consensus on what constitutes abscondment in the courts of appeals that have adopted our view of how this statutory scheme works.
Statutorily, supervised release can't go on for more than 5 years. Under your theory of this case, you're saying supervised release in part continues during the time of abscondment because they're subject to the terms of that they've violated, and yet it doesn't run out. Isn't that us by common law extending a period of punishment?
No, Your Honor. Our view
Tell me how not.
Well,
meaning if during the 5 years you violate those terms, you're still under supervised release terms. If you violate them, you're claiming that violation subjects you to a new warrant. How are we not extending the period?
So, Justice Sotomayor, a term of supervised release requires that the supervisee is both subject to
It actually does.
In
fact, it doesn't. The way the statute is written, it's up to the sentencing judge on whether actual supervision by the probation department is necessary. I grant you that I think in virtually all cases, most judges require it, but it's not legally required.
Well, Your Honor, I think if we read supervision out of supervised release, that essentially renders 18 U.S.C. 3601 and 3603 a nullity.
But then what happens to the defendant who is reporting every week, doing what he or she is supposed to do in terms of reporting to the agent, but is out there running a criminal enterprise every single day? That person, in my judgment, is not being adequately supervised. That person is violating the essence of the supervision, and yet you would claim he hasn't absconded.
Yes, that person is certainly violating his release conditions, and I want to be very clear that we do not view.
But that person could be not evading the entire spirit of supervised release, but that doesn't subject them to an extended period of supervised release, does it?
Well, I think the distinction there is that if that person is actually being supervised, if their whereabouts are known to their probation officer, if they are checking in with their probation officer as required by the terms of their supervision, then their violative conduct is much likelier to actually be detected and to result in a revocation hearing and a new sanction.
The reality is that it rarely is.
I don't know. I mean,